Hello, and welcome to the latest edition of the Board Brief, our video series that offers best practices in short, informative videos that you can watch on demand whenever and from wherever you want. My name is Eleanor Goldstein, and I will be moderating today's discussion about conflict resolution for board members. Every board member wants a harmonious and conflict-free community, but managing disputes is inevitable. When conflicts arise, you want to be equipped to handle them productively and efficiently. So, where should you start when you have a conflict with a resident, vendor, or even a fellow board member? Joining me for the discussion are David Estrello.
Hi, I'm a regional director serving our Central Florida market.
Thank you, David. And Jacqueline Kress.
Hello, everyone. Jacqueline Kress here in the Atlanta, Georgia market, regional director.
Thank you both for participating. So, David, before we get started, do you mind defining conflict for our audience? Can it be as simple as a disagreement between neighbors, or is it more involved than that?
Sure thing. A conflict is more than just a disagreement. It's a situation in which one or both parties perceive a threat, whether or not that threat is actually real. And because conflicts involve perceived threats to our own well being and survival, they stay with us until we face and resolve them. Conflicts trigger strong emotions. So if you aren't comfortable with your emotions or able to manage them in times of stress, you won't be able to resolve the conflict successfully.
And Jacqueline, what are some of the most common conflicts that your board members face? What do you think causes these types of conflicts?
That's a really good question. Board members face all sorts of conflicts, ranging from disputes with residents over failure to pay fines to billing issues with vendors. Conflicts can sometimes arise from different priorities or opinions, a lack of mutual respect or communication, or just because differing responses to change. A lack of board alignment can definitely lead to a conflict between board members. So we always try to make sure that your board of directors is aligned and understands the grievance and the conflict that's placed in front of them.
So, when faced with a conflict, where should a board member start? What is the first step to resolving it? Like, are there any techniques or tools that board members can use to help them with conflict resolution? David, can you elaborate on this some more?
Sure thing. So typically, the best approach is to try to avoid the conflict in the first place. Using clear and written verbal communication can help prevent many misunderstandings. Clarify the expectations and define them early to establish a baseline of what's expected. If that doesn't work, then start by talking calm and empathetic, and use a conversational approach. Everyone wants to feel heard and supported, even if they don't get what they want. So listen to what the person has to say. It's important to focus on the situation while keeping people and problems separate. Practice active listening, seek to understand the other person's point of view. Make sure that you use empathy and stay open minded. Make sure that everybody agrees on the facts and then explore the options together. Be collaborative, not combative. You always want to work with your property management company to learn additional best practices that may be specific to your individual community needs.
Those are great points. And if those approaches don't work, what else can boards do to resolve conflict within their community?
So, one way to resolve differences without litigation is through something called alternative dispute resolution. Mediation, for example, is often considered non adversarial, effective, and a cost efficient method of alternative dispute resolution. The entire process is facilitated by an independent and neutral third party, a mediator who works with both sides to discuss the issues at hand and come to a resolution. A mediator is not a judge, so rather than choosing sides or determining outcome, his or her role is to help both parties reach their own settlement agreement that they can each consider satisfactory and fair. Neither party is forced to accept a mediation decision, and they may leave the mediation process at any time if they feel that it does not serve their needs.
And Jacqueline, is arbitration an option? What's the difference between mediation and arbitration?
Good point. So arbitration is a less of a formal version of a court trial and is considered an adversarial form of alternative dispute resolution. It's mandated in some states and for certain association types. So arbitration is facilitated by an arbitrator and sometimes more than one, whose their role is similar to that of a private judge, and both sides are typically represented by attorneys. After listening to evidence and hearing sworn testimony from witnesses and reviewing relevant documents, the arbitrator makes a final decision, which may be binding or non-binding, depending on what both sides agree in advance or what is required by the law in your state. Non-binding arbitration is a type of arbitration where the arbitrator makes a determination and the rights of the parties to the dispute, but the determination is not binding upon them. So no enforceable arbitration award is issued. The parties can abide by the arbitrator's decision, or they can choose to move forward with a binding arbitration or litigation. So a binding arbitration is a final decision that usually cannot be appealed and to which both parties must comply. So if neither of these processes is successful, the next step may be a courtroom, litigation involving judges, juries, and attorneys. So before you take on any action, including mediation or arbitration, we would always recommend that you consult with your association's attorney to discuss the situation and understand your options and best practices to dispute the resolution.
Thank you for that explanation. Those are definitely good points to consider. So, David, what's a key takeaway that you would like our attendees to remember?
One of the main things is to always remain professional and to listen, right? Remember that conflicts are opportunities for growth. Make sure you familiarize yourself with common pitfalls and issues within your community and think of ways to collaborate or compromise. By finding common ground, you may be able to resolve the conflict through friendly discourse and good faith.
And Jacqueline, what would you like to leave our viewers with?
I'd love to reiterate that conflict is just, again, a disagreement, right? So it's getting the board to work together, understand the grievance, and not go to litigation or arbitration. Try to resolve that on an association level, partner with your association legal counsel. Before it can escalate. Litigation and mediation, again, can be extremely costly and timely to the association, as well as finding a time to be able to resolve that grievance.
Those are both great takeaways. Thank you. This has been a great discussion on a topic that impacts every association. Thank you, David and Jacqueline, for taking the time to speak with us. And to our viewers, thank you for joining us for this segment of the Board Brief. As a reminder, the information discussed today does not constitute legal advice, so please make sure you consult your association attorney for guidance. We hope you found the information helpful and will put it into practice in your community. Thank you.
Thank you for your time, Eleanor.
Thank you.